It's that time of year where the senators are in the House and the House members are in the Senate, so we're having trouble getting quorum over here. I think we got it right now, though.
Yeah, you're good.
All right. All right. I think we're ready. Yeah, we can get it. All right, good afternoon, everyone. Today is Tuesday, March 22nd. We have 9 bills on the docket. We'll start off with Delegate Lewis with House Bill 53. We'll then go to 78, then House Bill 91, 92, 161, 278, 283, 615, 616. So with that, Delegate Lewis, welcome to the Judicial Proceedings Committee. It's always good to see you. The floor is yours.
Microphone?
It should be,
It's red.
is it illuminated? There you go.
I'd forgotten how to do this, honest to God. Good afternoon. Esteemed Chair Smith, members of the Senate Judicial Proceedings Committee, Delegate Robin Lewis here on behalf of House Bill 53, Vehicle Laws, Dedicated Bus Lanes, Prohibition and Monitoring Systems. It's an honor to come before you. Thank you for letting me present on this bill. The House bill, I'm going to talk to you a minute from the heart. The technical and policy aspects of this bill you can read about, and I could talk to you for hours. But what I really want you to know is what this bill does. This bill improves the quality of MTA bus service for people who depend on it in Baltimore City and in the Baltimore metro region. Improving bus service is actually really simple, and all it requires is to move obstacles out of the way on dedicated bus lanes. These are lanes that are specially painted a bright red color to visually distinguish them from regular traffic lanes and to mark those lanes as special and exclusively for the use of city or MTA buses. Why does that matter? Because when you create a lane just for bus traffic, you allow that bus to move faster, more frequently, and more reliably. And ultimately, who cares if the bus moves frequently and reliably? The hundreds of thousands of residents of our state, many of them residents of Baltimore City, but also the Baltimore metro region, Baltimore County, Anne Arundel County, Howard County, who depend on access to good transit, have the same quality of service and ease of mobility as people who own cars. Back to the nitty-gritties, and I'll be brief. House Bill 53 is a reintroduction of a bill from 2021, House Bill 284, that passed out of the House, crossed to the Senate, was heard in this committee, but was not able to come to a vote. So some of you have heard this bill before. House Bill 53 is in the same posture as the bill that passed the House last year. The bill before you has a very minimal fiscal note. This is a local Baltimore City bill. It has no opposition. It's supported by the mayor and the Baltimore City Department of Transportation, and further supported by the Maryland Department of Transportation and the Maryland Transportation Administration, MTA. The bill is a product of a year-long work group, so it's been well thought out. It represents best practice. It was a year-long study group that included MDOT and resulted in recommendations that were the genesis of this bill. The last thing I'll mention, well, there's so much I could say, but I'll just mention one more thing, because I'm really passionate about quality transit. The last thing I'll mention is that a few months ago, U.S. Secretary of the Department of Transportation, Secretary Pete Buttigieg, announced a $22 million RAISE grant. That is a federal grant that will be dedicated to improve east-west transit across Baltimore City. And please remember what that means is it serves residents of the county and beyond. That $22 million grant for dedicated bus lanes and improved transit, better bus kiosks, better crossings, ADA compliance, and other interventions. That money really is dependent on having a local jurisdiction be ready to perform to make the most of it. And without this dedicated bus lane bill, our city and region will be at a disadvantage. They'll be unable to make the most of this federal largesse, which is once in a generation. With that, I'll close by urging your favorable report, and thank you.
Excellent. Thank you very much, Delegate Lewis. Questions from the committee? Senator Sidnor and then Senator Hedelman.
Good afternoon.
Good afternoon.
This is a local bill, correct?
Yes, sir. It's a local bill.
And would you mind sharing with the committee who your supporters are?
Yes, sir. This bill is supported by the mayor of Baltimore City and the local transportation agency, the Baltimore City Department of Transportation, Maryland Department of Transportation, MDOT, and the Maryland Transportation Administration, MTA, as well as numerous residents. And thank you for giving me the opportunity to share with you that my office did a little bit of a survey, really simple, not randomized or anything like that, but just a social media survey asking folks if they cared about bus service. And within about 24 hours of issuing that social media survey, we received over 100 responses from people who support this bill. And I'll just mention, for those of you in the room, in District 44A, we heard from residents of District 44A who said, pass this bill. There are about 2,500 people in District 44A who depend on MTA bus service every week. We also heard from residents in Baltimore County, District 11, looks like about 4,000 or 5,000 people a week depend on MTA bus service coming out of the Pikesville area every week. And we heard from dozens of folks in that region as well as folks from Catonsville, folks from Reisterstown, and from all over Baltimore City. So thank you for your question.
And any opposition?
There is no opposition to this bill.
Thank you.
Thank you, sir.
Thank you, Mr. Chairman. Good to see you,
Good to see you.
Delegate Lewis. And I do recall our field trip this past fall when I had the opportunity to see these bus lanes in work, in real time, and to hear from the folks in the city and state departments of education, departments of transportation about why the issue is so important. You mentioned that not passing this would be a real detriment in light of federal funding coming in. Can you elaborate on that a little bit, please?
Yes, ma'am. Thank you so much, Senator, for your question, and thank you for your generous sharing of your time to visit the city and ride dedicated buses and see what it's all about. The U.S. Department of Transportation is in the process of implementing the Bipartisan Infrastructure Act that passed last fall. There will be approximately $7 to $8 billion from that federal funding that will come to the state of Maryland. All of that funding is being allocated in the form of grants in some cases, and one of the grants under the Bipartisan Infrastructure Act is called the RAISE grant, and it's an acronym, and you'll find it explained in my testimony. I can't remember off the top of my head, but the RAISE grant in the amount of $22 million was awarded to Baltimore City to be used specifically to increase the efficiency and accessibility and equity of east-west transit across the city. That's important because the city lost the opportunity to have a light rail line, and that east-west corridor will help create a network that will really serve the city and the whole region. And as we know, when Baltimore City has a robust and active economy, it helps the whole state. So when you think about a small policy shift, a fine-tuning, this bill allowing Baltimore City to protect or enforce the use of its dedicated lanes, and how that helps the city stand in better light to demonstrate that its readiness and willingness to receive that kind of federal investment. A small change like this it's just really important. So I hope I answered your question, Senator.
Thank you.
Thank you.
Well, thank you, Delegate Lewis, for your advocacy for transit. Obviously, I've followed your work for a long time. We had a good conversation. So just thank you for your advocacy. Question for you is, so I was perplexed because in the testimony, I saw favorable with amendments from the mayor of Gaithersburg, and which was interesting to me. So yes, everything else is favorable from Baltimore City, and just a little bit of a conversation with council that a section when you're defining dedicated bus lane and you're creating this prohibition, it seems as though it has statewide implications, and so may not be a city bill. It may need a slight amendment. Just would love to get your take on that, because I think that's something we'll have to correct. Second,
you.
it would be, and I'll defer to Senator Sidnor, I don't know when the city delegation meets next, but we'd need a delegation letter, so I'd like to get that soonest if possible. We could talk to the chair of the city delegation so we could get a support letter.
Yes, thank you. Thank you so much. Thank you so much, Mr. Chair. Did you need me to respond to the letter from Gaithersburg?
Sure, yeah, so it's section, I don't know if, I can't see the actual testimony. I think it was favorable with amendments. I couldn't pull the document up, but I suspect she is talking about on page 5, section 21-101, and it just, when you create the definition of dedicated bus lane, it applies statewide.
Right. So I thank you so much for flagging that, because we're also, I think, not able to see opposition testimony in a committee that's not my own. So I appreciate that. So the definition of dedicated bus lane reads, a lane designated for use by mass transit vehicles owned, operated, or contracted for by the Maryland Transit Administration or a local department of transportation. The definition of dedicated bus lane, it's pretty clear there. I think the question is about enforcement and how local jurisdictions choose to enforce. This is enabling legislation. And what it does is it spells out very clearly that for Baltimore City, the power or authority to enforce a dedicated lane will be done by using existing stationary traffic enforcement cameras. Other jurisdictions have the opportunity to apply, to install and implement dedicated lanes as well. They may choose a different enforcement mechanism. So I don't think this is prescriptive, but I'd certainly be happy to discuss that further, and very willing to find a mutually agreeable consensus.
No, thanks. I think we'll take a look at it. It seems, so section 21-101 and 21-1113
Thank you.
seem to apply statewide, but we'll fix it.
Thank you so much, sir. Thank you, Mr. Chair,
Thanks.
members.
All right, further questions? Senator Hedelman?
No.
Oh, excellent. Well, it's very good to see you. Thank you very much.
Good to see you.
Thanks.
Great to be in the Senate. Thank
Thanks.
you.
All right. Excellent. And with that, that'll conclude the hearing for House Bill 53. We'll now move on to House Bill 78 with Delegate Rogers. Welcome. You've got a great second, number 2 on your bill here.
Good evening, Mr. Chair. I understand you two might actually know each other.
That's right, yeah. Delegate Trakudian. That's a solid.
Well, good evening, Chair Smith. I think I saw Vice Chair Wildstricker somewhere in the back, and members of the mighty Judicial Proceedings Committee. For the record, Delegate Mike Rogers, Legislative District 32, Anne Arundel County. And I'm here today to respectfully request a favorable rating report on House Bill 78. And basically what the bill does is it ensures that job applicants with disabilities have reasonable accommodations during the interview process, allowing these applicants to fully demonstrate their qualifications. House Bill 78 requires employers to make reasonable accommodations for applicants with disabilities, including allowing them alternatives to the application process, be it online or, if there are mobility issues, that sort of thing. As a nation, and in Maryland, we have an untapped segment of working adults and disabilities who are neither in the workforce nor looking for work. Enabling and supporting people with disabilities to enter and stay in the labor force is important, and I would argue imperative to growing and sustaining our GDP and strengthening our economy. A couple other notes. There's, on the House side, there were 6 testimonies in favor. I think 3 of them actually resubmitted those testimonies in support. There were no folks against it. In our committee, it was a party line vote, but interestingly enough, when it got to the floor, we were able to convert 5 of the 7 unfavorables to favorables and picked up a lot of other folks outside of Western Maryland who probably didn't get the memo. There's no meaningful impact to local or operational state funding, and you'll see a testimony that favorable with amendments, and that was already incorporated into the bill from the Maryland Civil Rights Commission. So with that, I request a favorable report on House Bill 78 and happy to answer any questions.
Just one quick question. Was this bill amended to address the State Commission on Civil Rights?
Yes, that was the last thing that I had mentioned, that Ms. Hughes, the counsel for the Maryland Commission on Civil Rights, we incorporated the verbiage that she was looking for specifically, since you asked, Senator, and I thank you for the question. House Bill 78 provides clarity to the state government article, section 2603, section 2606A, and offers the friendly amendment to remove the words "a qualified" on line 10 and in front of applicant, and the words "and" after "or" on page 2 of line 36. And basically what we're trying to do with that is make sure that an applicant without a disability is not required to establish being qualified.
Thank you.
All right, further questions from the committee? Senator Heddleman.
Was there a constituent with a problem that came to you? I'm just sort of wondering why this is necessary, given
Yes,
that it's supposed to be
absolutely.
covered under like the ADA, right?
Yes, Senator. A couple years ago, my good friend and colleague, Delegate Charkoudian, had the bill. And there was a constituent that had the problem. And since we've learned that there are many others, and the constituent's daughter did end up getting a job with the state once those accommodations were made. But because of that problem, and because others have since faced it, it's decided the clarifying and codifying this would help a lot of other people, in essence. And so 2 years ago, just to add to that, she had the bill. It was thought that it wasn't needed. Come to find out it was, so we're bringing it back. She withdrew it 2 years ago.
Okay, thank you. Helpful.
Senator Watson? Thank you. One question.
So, in the actual implementation, somebody goes in for, job application process, right? And you're saying that this bill says that they have to show that they are a qualified applicant and have any required means to support their disability there at the time they go to try to find a job?
So that's exactly to my response to Senator Signer. That's taken out. That was the word. We're not saying require an applicant with disability to establish being a qualified applicant prior to receiving reasonable accommodations creates more of a problem. So we took qualified out. That was what the amendment did, the favorable amendment from the Maryland Commission on Civil Rights did. And that was already incorporated into the bill after it came through Economic Matters.
So striking qualified out, if
So
someone,
it says an applicant, correct.
so if an applicant with a disability is coming for a job interview and you have knowledge of that disability beforehand, you're required to make reasonable accommodations.
Correct.
Got it. Thanks.
All right, thank you very much. Thank you for bringing this bill to us. And with that, that'll conclude the hearing for House Bill 78.
Thank you.
All right, Delegate Rogers, good to see you.
Always
Thanks
a
a lot.
pleasure.
All right, next we'll have Delegate Holmes. Welcome.
Good afternoon, Judiciary Committee, Judicial Proceedings. For the record, my name is Marvin Holmes, and I have before you today House Bill 91. House Bill 91 is a bill that I have been working very closely with Department of Assessment and Taxation to make it easier for Marylanders to redeem ground rents on their homes. The bill requires all notices of intention to preserve irredeemable ground rents to be filled out with SDAT. And there are two types of ground rents. There are redeemable ground rents and there are irredeemable ground rents. And this bill is specific to irredeemable ground rents. The history of ground rents is something that's kind of odd. I think perhaps, Mr. Chair, it might have been established, as I recall, sometimes in the summer of 1634 by King Charles I, I think. And right now there's only two states that have ground rents, Hawaii and Maryland. But the bill, HB 91, makes it so that the ground rent registry should contain, the ground rent registry should contain all the documents as necessary for the irredeemable ground rents. I have with me Jonathan Glazer from SDAT to answer any technical questions that you may have with reference to these irredeemable ground rents. And in our letter from my testimony on the House side, letter from the Office of the Attorney General, the letter says, and I quote, "While owners of irredeemable ground rents are currently required to provide renewal notices of leasehold tenants, the provisions of House Bill 91 will provide current and future leasehold tenants with the additional protection of reasonable source to confirm whether a ground rent remains irredeemable." And if I could also, Mr. Chair and members of the committee, read from a letter that was provided, a letter of information that was provided to us on the House side from SDAT. And this is, the one paragraph of the letter is really telling in terms of the need for this particular bill. And in this letter from State Department of Assessment and Taxation, letter of information, it reads, and I quote, "This bill aims to solve a critical problem that ground leaseholders face when redeeming a ground rent through SDAT. Currently, every ground leaseholder must hire a title attorney to prove that a certain document was not filed in the land records. This is the only situation where an individual must hire a title company to prove that ground rent document does not exist." And what this bill does, it circumvents that process where the tenant has to hire a title company to prove that the documents do not exist. SDAT, I want to compliment SDAT in terms of making it easier for those persons to find out if the ground rents are redeemable or irredeemable by putting it on their website, and we can remove the requirement for a title company to be hired just to find out that the document has not been filed with SDAT. And with that, Mr. Chair, I will answer questions. And like I said, SDAT is here to answer technical questions as well.
Excellent, thank you, Delegate Holmes. Well, ground rent is certainly a peculiarity that I've never understood. So this irredeemable, so if anything filed before 1884, is that right? As I'm looking at the fiscal note, is an irredeemable ground rent is something that's was created or executed before 1884. So this bill essentially says, look, right now you've got to hire a title search to clear title, basically. How much does that cost someone?
Well, if you hire a title company, it's just like hiring an attorney.
Yeah.
Because that's what that is. However, with this bill, the cost would be $20. And I would, if I could, Mr. Chair, have Mr. Glacier from SDAT to explain that process as well.
Yeah, so certain ground rents that were formed before 1884 are irredeemable. Certain
it.
ones are redeemable. In order to preserve the irredeemability of a ground rent, a ground lease holder has to file a document every 10 years with the Baltimore City, most often, or another land records office. This bill aims to make it so a duplicate copy is filed with SDAT.
Okay.
Right now, every ground rent related document is filed with SDAT except the super specific one. So this brings in line that just like all other ground rent related documents, it should be filed with SDAT. That way we can have all of a property's ground rent documents available in one place.
Understood. Okay. Senator Sidnor.
Thank you. Could you explain what an irredeemable ground rent is? I mean, I'm
Great.
curious what's the purpose if you can't redeem it?
Great question. So originally, when ground rents were established, Lord Baltimore way back when, most ground rents were irredeemable. All irredeemable ground rents are now redeemable, all of them, except for ones that filed this intention to preserve the irredeemability before December 31st, 2010, and then they had to file it every 10 years, so they've had to file it once subsequently in order to maintain the irredeemability of the ground rent. So while it's still called an irredeemable ground rent, in practice, there is a schedule described in statute for what the payout is of these irredeemable ground rents. A person will come to SDAT, say, SDAT, here's the information. They will pay SDAT a lump sum. SDAT will hold that money in escrow in case a future claimant claims the ground rent. And if nothing is claimed within 20 years, that money goes back to the general fund.
Was this an effort in the state to attempt to get rid of ground rents?
SDAT has already attempted that, and that was ruled unconstitutional.
Oh, okay.
So SDAT, yeah, so that already went through. So this is, we're very careful. We don't want to eliminate the property right to ground rent. It's a property right. The courts have maintained that. But what we do want to do is make it easier for homeowners to redeem their ground rent and hold their property in fee simple.
So if the person doesn't file this document in 10 years, it becomes redeemable?
Correct. If the ground leaseholder does not repeatedly file this document every 10 years, the ground rent is then redeemable with the department.
And that keeps you all to staying constitutional, and I got you. Thank you.
So I presume the constitutionality, did it deal with takings? And if so, like, how do you, if you don't know who has that title or who has claim to the title, how do you solve that problem?
So the whole constitutionality aspect has been solved with the redemption program. It really has nothing to do with this. It has nothing to do with this bill. This bill is simply allowing a duplicate copy of something that's already filed with Baltimore City Land Records to be filed with SDAT. That's all this bill does, is a duplicate copy of something that's already been filed.
Understood. Senator Watson.
And so the reason you want it filed with SDAT as well, just to make it easier to do a search on it?
Correct. So far, every other ground rent related document is filed with SDAT. Amendments, registration, redemptions, this is like the one specific document, and frankly, we don't know why it wasn't required originally. It might have been an oversight. That's what it sounds like from the original ground rent committee. But it's just this one specific document that's not filed with SDAT. We want that to be part of the, on our real property data search, which is free for everyone, you can look up every property and see whether a ground rent is registered with SDAT. While a ground rent may exist if it's not registered with SDAT, it is only enforceable under law if it is registered with SDAT.
So currently in Maryland, somebody can own the ground, somebody can be renting property on top of the ground, and if the tenant doesn't pay the person who has the ground rent after a certain period of time, they can go after what's on top of the ground?
Correct.
Right.
That is correct.
Exactly.
One of the purposes of SDAT is that if it is not registered with SDAT, that collection process cannot start. it must be registered with SSTAT before that collection can start, and that protects a lot of ground lease tenants. Another good thing to know is upon registering with SSTAT, a ground leaseholder can only collect 3 years of back ground rent. So it's not like you can register with SSTAT and say, hey, you owe me 100 years of ground rent. You can only get 3 years of ground rents. The Department of Legislative Services has said the average ground rent redemption amount ranges from $1,700 to $3,300, with a typical ground rent being around $2,500 to redeem.
Well, I understand the bill, but the concept of ground rent is still as clear as mud to me, but,
If I may, Mr. Chair?
yes, sir.
That the whole process of how this started from a couple of weeks ago, back in the 1600s. If you wanted to build a castle on the king's land, you owned the castle, but you had to send your money over to England to pay a rent on the land that you built your castle upon. That's where it all got started. I think sometimes in the summer of 1634, sometime back in those days. But like I said, only 2 states left, Hawaii and Maryland.
And Mr. Chair, I want to say that about 2 weeks ago, Director Higgs did launch that we have sort of relaunched the ground rent program to make it even easier than ever to redeem and get rid of your ground rent through SSTAT, and we've had a great response. And if any of you guys have any constituents, please send them to SSTAT. We've updated our forms. It is a easy process, and it only costs $20 to get rid of your ground rent now.
Well, thank you for the work on that. We are a democratic republic, not a feudal system, so I appreciate your efforts. And thank you, Delegate Holmes, for bringing the bill forward. We'll work on this. Thank you. All right, further questions from the committee? Seeing none, thank you all very much.
Thank you so much.
That'll conclude the hearing for House Bill 91. We'll now hear from Delegate Hill with House Bill 92. Welcome.
Thank you very much, Mr. Chair and committee members. Good to see you guys. For the record, I'm Terry Hill, and the bill I'm presenting for you this afternoon is House Bill 92. This is a bill we presented last year. It crossed over from the House both this year and last year unanimously, and is in the same posture as last year, with the amendments that were requested in the testimony that you've also been given from last year having already been incorporated. In essence, what HB 92 will do is it will alter the current Maryland statutory form for personal finances and Maryland statutory form for limited power of attorney, so that a person can assign an agent to handle their financial affairs and their property matters on their behalf, access the financial, medical, and other supporting documentation required in applying for Medicaid on behalf of the principal, hire a Medicaid planner, which is really important, and pay for Medicaid planning services using the principal's income or assets to further help them gain Medicaid eligibility, and avoid the potentially expensive and lengthy process of pursuing guardianship should the principal, usually a loved one, become incapacitated. This is the result of the Life and Health Planning Committee and the Attorney General's COVID-19 Access to Justice Task Force. I know you saw a lot of legislation coming out of that, and I'm hoping that you will look favorably upon this bill and that we've gotten it to you a little earlier this year and you'll have time to act on it. I think it's really critical. We have the support of the Elder Law section, Elder Law and Disability. We worked with the Real Estate section to have their support, and you should have testimony both from last year and this year from attorneys working in the field, as well as supporting testimony from the AG's office. So, any questions?
All right, thank you, Delegate Hill. Questions from the committee, seeing Senator Watson.
Thank you, Delegate Hill. This is an interesting bill because it looks like, I've never seen a bill like this. It looks like a how-to guide with a built-in template.
Right.
So someone who wanted to go through this process would literally pull this bill, complete the information specifically on this form?
We can typically go to the AG's office, sometimes to the court libraries, pull the form. It's a statutory form. They can fill it out, and without having to hire attorneys. And the main thing here is without having to go through a guardianship petition and get the court's approval, they can then act as an agent on behalf. And particularly for people who are on Medicare, when they are trying to, if they're disabled and they now need to apply for Medicaid, they have to spend down their assets. And this form was designed about 12 years ago by the General Assembly, power of attorney, in order to allow them to sort of preserve some assets for their family members and not make them destitute. But one of the things that was missing in that form was the ability for them to do it for financial assets. And so this would correct that and allow them to do that. So yeah, this is a statutory form that we created, and this would just make a small change to both of those forms.
Got it. Thank you very much.
Thank you.
All right, seeing no further questions from the committee, thank you, Delegate Hill.
Thank
Good
you
to see
very much.
here.
I asked for a favorable report. Appreciate you guys.
Excellent. All right, with that, that'll end the hearing for House Bill 92. We'll now move on to Delegate Shetty with House Bill 161.
Good afternoon, colleagues. It's so great to be here with you today. Chair Smith, I saw my vice chair and district mate in the hallway earlier. Hello, esteemed members of Judicial Proceedings. For the record, I am Delegate Emily Shetty, here to testify in support of HB 161, a bill that will strengthen our laws that protect seniors and vulnerable adults from undue influence. This concept probably sounds familiar to you. I've been before you all before on this issue. So this bill is actually very similar to a bill that I had in 2020 and 2021. And last year, your committee did consider this along with a related bill that was championed by the vice chair, Senator Wallstreicher. So the senator's bill provided critical protections to vulnerable adults within our civil system. And this bill that's before you today is a companion to that effort that seeks to build upon the important reforms that your committee enacted last year by addressing undue influence from the criminal side. So this year, HB 161 passed both House Judiciary as well as the House of Delegates unanimously. Undue influence is a legal doctrine. It is often incredibly difficult to prove, in part because these cases often occur behind closed doors and without witnesses. In addition, the law lacks a clear definition for what undue influence actually is. The issue is often complicated by the assumption that mental capacity and undue influence are linked, which is not always the case. For example, one could be of sound mind and still fall prey to undue influence due to other factors, such as the relationship between the influencer and the victim. This bill will strengthen our criminal code as it pertains to the definition of undue influence of a vulnerable adult, specifically as it relates to the transfer of property. So the idea for this bill came by way of a constituent of both mine and the vice chair's. Her name is Claudia. Her late uncle was defrauded by their financial advisor. His advisor convinced the uncle to place the advisor into the uncle's will as the sole beneficiary prior to his passing. It's really important to note that while there was a civil suit that was settled, a criminal case was never pursued, in part because the standard in Maryland is so difficult to prove that cases like these are rarely successful. Claudia remains a great supporter of this bill, and she's very hopeful that the criminal code will at last be amended. It's our shared hope that other families in her position will have the opportunity to hold people abusing their positions of influence over vulnerable adults accountable. When we connected with her recently, she shared that her understanding was that the bill passed last year that your committee worked so diligently on was meant to complement the bill before you today, and she will cheer when this one passes, as it would actually address the case that affected her family and many, many others. So really briefly, what this bill does is it adopts some language based on a California law enacted in 2014 after a multi-year study on how to protect seniors from financial exploitation via undue influence. So it provides a really clear definition for undue influence. It's based on detailed recommendations by psychologists, sociologists, criminologists, victimologists, legal experts, and courts that have focused on 4 things. Number 1, the victim characteristics that contribute to vulnerability. Number 2, the power dynamic between the influencer and the victim. Number 3, improper actions or tactics taken by the influencer. And number 4, unfair, improper, unnatural, or unethical transactions or outcomes. So all of these components are addressed in the bill before you. And I just want to quickly explain the only difference between this year's bill and last. So the Montgomery County State's Attorney's Office reached out to us and requested that we remove the previous language, quote, amounting to force and coercion, end quote, from the bill, as criminals today don't have to resort to force and coercion in order to pursue their goal of having a victim transfer property to them. In fact, so for example, an internet phishing scam, it often involves skilled requests from a perpetrator. It exploits an elderly or vulnerable person's fears or lack of resources, but none of these amount to force and coercion. So removing this language helps cases go forward in situations where an individual willingly gives up assets due to this sort of undue influence. So colleagues, I respectfully request a favorable report on HB 161. Thank you for your consideration, and I would be happy to answer any questions.
Excellent. Thank you very much, Delegate Shetty. Looking to the committee for questions. Seeing none. Your testimony was just that good. All right, seeing none, thank you very much. That'll
Thank you, colleagues.
Thank you. That'll end the hearing for House Bill 161. We'll now move on to Delegate Davis with House Bill 278. Welcome.
Good afternoon, Chair Smith and colleagues of Judicial Proceedings. For the record, my name is Deborah Davis. I'm from District 28 in Charles County, and I'm here to present HB 278. It has a long title. It's entitled Correctional Services Inmate Cost of Living Report, Maryland Correctional Enterprises Diversity Report. It should sound familiar. I believe you heard it at least 3 times before. It is simply a reporting bill for the Department of Corrections with no fiscal note. When passed, this bill would expand reporting requirements established in 2019, spearheaded by your own Chairman, Chairman Smith. The bill targets the annual costs of living for inmates, including the average cost of telephone calls, including calls to medical providers, video calls, and items available for purchase at commissary, including feminine hygiene products, toiletries, and medications. And it would require the Department of Corrections to list the race, sex, and age of inmates currently employed at facilities under the authority of Maryland Correctional Enterprises, disaggregated by job classification and wage scale. Colleagues, as a member of the Judiciary Proceedings, you're aware of the Department of Corrections and that it has 17 state correctional facilities and the Maryland Correctional Enterprises, which reports upwards of $61 million in revenues. We believe inmates earn as little as 25 cents an hour, contributing to this multi-million-dollar revenue stream, all while there are reports of costs behind the walls increasing exponentially. During the COVID shutdown alone, when inmates were not allowed to work, the cost of commissary remained the same, creating even more hardships for families of those incarcerated and already financially stressed. It is incumbent upon us to answer the concerns of family members and to ensure complete transparency. After all, as policymakers, we can't address what we can't see. I respectfully request a favorable report.
Delegate Davis, thank you very much. We have questions from the committee. I saw Senator Lee first and then Senator Watson.
Delegate Davis, thank you for bringing this bill again and your work on this. I'm particularly concerned about the information collected about female inmates. That would be included in this too, including things like toiletries and...
I'm sorry, Senator Lee, I can't hear you.
Okay, let me move this. Okay. Can you hear me now,
Yes.
Delegate Davis? Yeah, again, thank you for bringing this bill. I'm very concerned. I hope that this bill also covers information about female inmates, and particularly maybe inmates also that are pregnant too, and items such as toiletries and personal items that are necessary for because I think that's an area that has been underreported. Does it include that type of information as well?
Yes, it does.
Okay.
Thank you, Delegate Davis. Inside prison, if a inmate is working through MCE in one of their programs and making some money, does that money go to the inmate's commissary card? How do they actually get the money?
Honestly, Senator Watson, I do not know.
Well, I guess the point I'm getting at is that not everybody can get a job in prison, right?
Absolutely.
And so some folks will be doing some type of labor or work, some won't. Yet looking at what, who wrote this response? Department of Public Safety and Correction, all the inmates get pretty much the same thing. You know, the food daily, shelter, you know, X, Y, and Z. And so my question is, by gathering this data, you know, what is the goal? What do we expect to achieve and be able to do with the information?
Well, actually, we do not know what they get, what they actually get, and we do not know what some of the costs are. We recently, maybe last year, we got a list of costs for some of the commissary. One of the inmates slipped it out of the jail. So we were able to get that. And there were things like underwear being charged $5 for. So actually, you'd have to work 2 weeks to buy an extra pair of underwear if that's what you wanted. And there are also reports that, that some things like toothbrushes, that you're being charged $10 for a toothbrush. All right, and so we believe that we need the information in order to investigate it. This would just give us the information so we can investigate some of the complaints that we're hearing from family members.
Thank you. And I didn't see it in the bill, but if a person's making money through MCE, you know, to me, there are two options. Either that money is held for this person so that when they get out, there's something that they can take out with them to try to start anew, or they're giving that money up front on some type of commissary card or something like that. You know, my issue is that still, whether they're getting money now or later, not everybody has access to it. You know, so not everybody has those opportunities. But I would love to know, through MCE, those folks who are working in these disciplines, how do the inmates get paid? How do they get it? We definitely want to know how much, because we talked about that, you know, last year. We definitely want to know how much and help, you know, with our broader transparency that we've been working on to collect data so we can make better decisions. But how do they get the money? And I'd love it if you could help me get the answer to that, because I haven't been able to figure that out.
I sure would.
Right.
That's why transparency is so important. But
Yeah.
I'd be glad to ask the question and see if we can get an answer.
Thank you.
Thank you.
Thank you so much. Thanks for bringing the bill, Delegate Davis. So I don't know if you know about this, but this bill just triggered something interesting, because for many years ago, back when I was in the House of Delegates, we had legislation about the inmate telephone calls, which were astronomical, especially, you know, their families bore the cost oftentimes because they would have to do it collect. And I know that they took some measures to try to change that. And then in the pandemic, the department contended that they were offering free video calls because there was no visitation. And I'm just wondering, and I was hoping that was something they would keep up. Did you get any intel on what those costs are now, or what how if any, the telephone calls have changed?
Thank you for the question, Senator. What we've received is a letter from the Department of Correction that says that they suspended the costs for video conferencing. They did not say whether they've reinstituted it or they haven't reinstituted. It's only to be assumed that it will be reinstituted just by the word suspended.
Further questions from the committee? Senator Heddleman.
Mr. Chairman, good to see you, Delegate Davis. I understand, and I remember this bill from last year, and I was just looking at the testimony from the department where they say that they can't really provide an average cost of living for inmates. And so I wanted, A, to know your comment on that, and B, how you would feel about asking them for specific costs for the items that that are included in the bill. I mean, they do say it's $5,030 per incarcerated individual per month, including overhead. But I do totally understand the point and the wisdom of wanting to get kind of line items for the other things that you're asking for in this bill. So I just wanted to give you an opportunity to comment on that.
Yes, I read that, and it was a bit disturbing, because if you're running a $60 million organization and you're actually paying people, there should be some record, and it should be easily accessible. If not, it's not run well. I'll say that at the very minimum. And your other question was,
Well, I'm asking really, do you want an accounting for what that $5,000, how they get to that number? Is that what you're looking for precisely?
we're looking
When you
for the,
say the cost of living, for the average cost of living for inmates,
so it would be all the other costs.
what
It would be all the other costs that have been outlined. The telephone calls, video calls, and the commissary purchases, including, as the senator mentioned earlier, feminine hygiene products, those costs. And you know what? What happens is that it's tantamount to slavery when you're paying people $25 an hour and you charge them $10 for a toothbrush.
So that's your main point of this, is wanting
Yes,
to know
that-
the earnings and the expenses that they have to-
Absolutely.
Okay, that's helpful. Thank you.
No, Delegate Davis, thank you very much for bringing the bill. It's important. I think you're right. Your adage at the end was important because we can't make informed policy if we don't have the right information. But you said, MCE, you said $60 million? Did it?
Yes.
That's incredible.
Yes.
Because, you know, if you look around the room, most of the furniture that everyone's sitting on is MCE. A lot of stuff we have in our offices is MCE. So that's incredible. I know that Delegate Wilkins had a bill, and I cross-filed with her to find out the salary or the amount of money they're working on. So I appreciate the bill. Thank you for bringing this. It's great.
Thank you.
Thank you. All right, further questions from the committee? Seeing none, that'll conclude the hearing for Senate Bill, or House Bill 278. Thank you very much, Delegate Davis. We'll now hear from Delegate Jones with House Bill 283.
Good afternoon. Good afternoon, Chair Smith, Vice Chair Wallstreiter, and members of the Judicial Proceedings Committee. For the record, I am Delegate Dana Jones, representing Annapolis and Anne Arundel County. I am so honored to be here with you all today, in person at that. I come before you today to introduce a bill that passed unanimously through the House, as well as the Environmental Transportation Committee. This protects our children from a preventable dangerous problem. Many of our students are forced to ride on overcrowded school buses that don't have enough seats for all students, with some students even having to stand in the aisle, sitting in the aisle, and on the floor, as well as sometimes sitting on each other's lap. This goes against the National Highway Traffic Safety Administration's recommendation that all school bus passengers be seated while a school bus is in motion. This bill initially came about when parents in my school district reached out 3 years ago about the problem after their concerns were dismissed by the school district officials, which they used state law as the rationale for overcrowded buses, specifically saying, well, Maryland law allows for several students, 3 students per seat, and that students are allowed to stand. I've also in the past had school board members from Anne Arundel County testify in favor of this legislation. News reports from prior to the pandemic have confirmed that this is a problem in several counties throughout the state of Maryland. For example, in 2019 performance audit of Anne Arundel County public schools found that the school system is not managing its transportation services efficiently and suggested that overcrowded buses could be solved through the application of routing software, which all counties already own. It's just the will to use it. So we have some buses coming to school which are half empty, while others are full plus another half of a bus. We can all agree it's essential to secure the safety of our children, students after a long day at school. Students can easily become rambunctious and ready to start the afternoon and/or after-school activities. Additionally, this bill includes language that would allow for the limit of students to temporarily exceed seating capacity in cases of emergency, as long as it is corrected in a reasonable amount of time. I am proud to have the endorsements of both the Maryland Transit Caucus, the Maryland School Bus Contractors Association, and again, this bill simply requires that school buses be routed with the intent that the number of pupils on the bus does not exceed the manufacturer's rated seating capacity for a bus. And so I ask respectfully for a favorable report, and I thank you so very much.
Well, thank you very much, Delegate Jones. I'm struggling. I want to ask a question because we've killed this bill at least 3 years in a row, and I want to make sure, give you a fighting chance for it, because just to give us a different testimony, enlighten us with some different information, because I think it died 6-5 last year.
Yes, sir.
So can you do this locally, or is it something that has to be a statewide change, or?
Well, good news, sir. It hasn't been killed 3 years in a row. I was appointed just last year, so it was moved unfavorable last year in this committee. And after hearing from so many constituents that this is a critical problem that can easily be solved, that there's effectively no fiscal impact on this bill, and the local effect slightly might increase, but truly there isn't a real fiscal impact here. So all of our counties have transportation routing software, for which some use and some don't. And if we apply that software that's there, then we can easily solve this problem. But the intent of routing a bus knowingly that you're putting 60 children, if there's only room for 40, shouldn't be something that folks can fall back upon as an excuse, if you will.
I appreciate that. Senator West, I expect, it was your predecessor, and maybe I misspoke, maybe not 3 years in a row, but 3 years we've done it, because your predecessor had this bill, or didn't like this bill, I think. Brochin, Senator Brochin. Yeah.
That was.
Maybe seatbelt?
Yes,
Okay,
sir.
maybe I'm
No.
misremembering.
The first year, with all due respect, the first year it didn't make it across. My
Got it.
predecessor, Alice Kane, filed it, and you all had to adjourn early
Got it.
for the first time due to COVID, so it did not make it across to the Senate. And last year, when I then was appointed and was in office, as constituents continued to come to me concerned about this, that's the year that this very bill came over last year.
Understood.
Thank you.
Senator West.
Yes, sir.
Thank you, Mr. Chair. Do you believe this problem can be solved just by rerouting the buses so that the buses all fill to, I guess, near capacity rather than one over capacity and others under capacity?
Thank you so much for that question, Senator. I have multiple, audits on school systems from 2019 as well as 2020, which I can provide and bring copies to you, that really outline that many of our buses are showing up half empty, while some are over full.
Right.
So I do believe that a large majority of what we're dealing with here, if the intent is pure, that we cannot knowingly, willingly put too many children and too many bus stops on one bus, that this could, in fact, solve this problem. Yes, sir.
I'm surprised that school authorities wouldn't have figured that one out.
Well, thank you, Senator. I would agree. Some have, in all honesty, some have. We have, I believe at last count and after COVID, getting some of this information was a little bit more difficult. But we have 18, I believe it was, and I can find in my too many notes, 18 of 24 school districts started to use the routing software, while others were still having issues and the willingness or.
And I guess if the school system can't reroute the buses to make sure that no bus is overcrowded, then the only alternative would be to buy more buses, and thereby alleviate the crowding problem. But that's going to cost money. Did MACO take a position on this bill?
No, sir.
Okay.
No, they did not.
Thanks.
Thank you so much for this.
Yes, Senator.
As a former school board member, I remember the days where the bus driver would look back, everybody take a seat before they pulled off, and I guess things have changed. And so I appreciate it, and you're right, spot on about the routing software. My question is, not being here for prior versions of the bill, it seems like there would be a logical comparison between school buses and public buses. And in public buses, you can stand as long as you're behind the yellow line. And I guess that's assumed to be safe as long as you're behind the yellow line. But that's not the case, I guess is what you're saying for our public school buses. And I was just hoping you could address that, because I figured that if there's going to be a sticking point, that would be it.
Well, thank you so much, Senator, for your question. With our public buses, we have handles, we have bars, and we have adults using them. On our school buses, I am a mom of an 11-year-old, and I can't promise you that every time I give the first directive, well, that directive is followed. There is not bars, there aren't handles. We have children of different heights, and so the ability or the lack of anything to hold on to, right? First off, isn't there. We are dealing with juveniles. And we've made it through the entire school day, and we got the wiggles and everything else, right? So those are two different situations, stark comparisons, and I'm thankful that you did bring that up.
Thank you very much. Appreciate it.
Thank you, Senator. So thank you so much, and I appreciate you all. This is the first time I've been able to come over. Last year, the first year I had this bill, I was not able, obviously with COVID, to come over and talk about this, so I'm glad to have your questions, and I can follow up if anyone has any others.
Of course. Well, thank you very much, Delegate Jones. Always welcome in JPR.
Thank you so very much.
All right, thanks. With that, that'll end the testimony in the hearing for Senate or House Bill 283. We'll now hear from Delegate Healy with House Bill 615 and 616. Welcome.
Thank you, Chair Smith. Thank you, Senators. I'd like to present both of these together because they're very similar. House Bill 615 is about condominiums and homeowners associations, and House Bill 616 is about, 615 is about one of them, and the other one is about the co-ops. Because they're written in different parts of the law, they're separate bills. But they essentially do the same thing, which is to allow for dispute settlements. This bill has passed the House unanimously and passed out of the committee unanimously. And it has not had a vote in this committee, although it has come over before for a variety of reasons. A growing number of Marylanders live in common ownership communities, up to an estimated 1 million residents as of 2020. However, current law does not specify how disputes are settled between the homeowners associations or the condo associations or the co-ops and their residents. These groups have increasingly found issues with governance, dispute resolution, and financial stability. This legislation will alter how those disputes are handled. For condos, if a resident commits an alleged violation, requests a hearing with a set time period from the notice of the violation, the board must provide written notice of the time and place of the hearing, no less than 10 days after a hearing is requested. If no hearing is requested, then the resident accused of the violation, the board may then decide that at its next meeting if the violation occurred and if a sanction is appropriate. It prohibits the governing body from imposing fines or taking away any rights of a lot owner, for instance, voting, unless a written cease and desist order has been sent to the alleged violator. Basically, this is from the Association of Communities, and they've been trying to get some kind of standardized way of doing this, and they've approached me a couple times, and I'm happy to present it to you today. Happy to answer questions.
All right. Cold bench here. Thank you very much.
Thank you.
All right.
Have a beautiful day.
Thanks, you too. It's good to see you in person. It's been a long time. All right, with that, that'll conclude the hearings for House Bill 615 and 616 and our hearings for the day. That's it. We're done. That's awesome.